afternoon. My name is Sheila Lamb, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 26 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Intellectual Property Fundamentals, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. Be sure to save the dates for the next webinars in this series, Patent Basics on Thursday, March 26th, and Trademark Basics on Tuesday, April 28th. And I'll drop those registration links into the chat momentarily. We are recording today's presentation and it will be posted on our website, virginiasbdc.org. Due to the large number of expected participants, everyone's microphone is muted and the chat feature is turned off. But if you have questions during the presentation, you can type those into the Q&A box and we will adjust them at the end of the session, time permitting. We have also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session, Elizabeth Doherty. As the Southeastern Regional Outreach Director for the U.S. Patent and Trademark Office, the USPTO, Elizabeth carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, and is responsible for leading the USPTO's Southeast Coast stakeholder engagement. She has more than 25 years of experience working with the USPTO. Elizabeth has dedicated much of her career to the USPTO's outreach and education programs, focusing on small businesses, startups, and entrepreneurs. In this effort, she has developed, implemented, and supervised programs that support the independent inventor community, small businesses, entrepreneurs, and the intellectual property interests of colleges and universities. Similarly, Elizabeth has spearheaded a number of special projects with federal, state, and local governments and private organizations to promote and support invention and innovation in the United States. Focusing on the Southeastern region and actively engaging with the community, Elizabeth ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. Please join me in welcoming Elizabeth Doherty.
Thank you, Sheila, for that kind and lengthy welcome. You know, as I like to tell people in my role as the Southeast Regional Outreach Director, it's a very long title, but it really boils down to I help people. I help people who are looking to learn more about the role and importance of intellectual property. Why is it important to them? Why should they care, particularly as a small business owner or entrepreneur? And that's what we're going to talk about today. We are going to talk about intellectual property from start to finish, covering all of the 4 basic types of intellectual property, and then ending with a highlight of a few USPTO resources available to you. Now, those USPTO resources will also be repeated in a future webinar, but I want to whet your appetite by talking about some of them today. With that, we are going to jump right into our materials, Intellectual Property Fundamentals, Grow Your Knowledge and Know-How. I'm excited to be on with you today and talk about my favorite topic, intellectual property. So what are we going to talk about today in our beautiful time together? We're going to talk about what is intellectual property, or oftentimes referred to as IP. How is IP relevant to business creation and growth? What is the U.S. Patent and Trademark Office? Because you may not have engaged with us before. What are trade secrets, copyrights, trademarks, and patents? And again, an introduction to some of our USPTO resources. So let's start with the basic question, what is intellectual property? And very honestly, why should you care? Well, intellectual property and the rights protected here in the US are as old as the nation itself, or nearly as old as the nation itself. I know this year we are celebrating America's 250, and the USPTO is right there alongside other individuals, organizations, companies, and businesses celebrating America. Intellectual property began with the drafting of the Constitution, which sets forth intellectual property rights. If you look at Article 1, Section 8, Clause 8, This is what we know as the Patent and Copyright Clause, which sets forth that Congress shall have the power to promote the progress of science and the useful arts by securing, for limited times, and we're going to talk about that, to authors and inventors the exclusive right, the right to exclude others to their respective writings and discoveries. Now, trademarks are also inherently within the Constitution, and they're found in the Commerce Clause. So think about it. Our work began in 1790 with the issuance of the first US patent, so we're not quite as old as the 250th anniversary of the nation, but we're pretty close. So when we talk about intellectual property, it's often helpful to juxtapose it against real property. Real property is tangible property and something we can all appreciate. It's that house, that car, that boat, that tangible property that we can feel, that we can buy, that we can lease, that we can give away, that we can assign to our heirs. Intellectual property has a lot of those same respects, but it is intangible property. It is the creative property of the mind, perhaps of you or a group of individuals working together to develop a creative solution, a creative brand, a creative work of authorship. So intellectual property, keep in mind, is that property of the mind. It's intangible property, but yet it can be bought, it can be sold, it can be licensed, it can be assigned to our heirs, it can be given away freely. So it has intrinsic value. So let's keep in mind, just like real property, intellectual property brings value, particularly if you are a business owner. Just as you have your portfolio of real property, those hard assets, perhaps the building where your business is located. Perhaps you have a fleet of vehicles. Perhaps you have equipment. That is your real property that is part of the bottom line of your business. Your intellectual property portfolio should be too. So today we are going to talk about the 4 basic types of intellectual property: patents, trademarks, copyrights, and trade secrets. As our name suggests, the U.S. Patent and Trademark Office issues U.S. patents and federally registers U.S. trademarks. Copyrights are protected by the U.S. Copyright Office, which is a part of the Library of Congress. Trade secrets are generally protected by contract law or legislation such as the Uniform Trade Secrets Act. What I want you to take away from our conversation today is that these 4 types of intellectual property each protect 4 very different things for different durations. And you, no matter what endeavor you're undertaking, may be creating one or multiple forms of these types of intellectual property in any endeavor you're undertaking. Patents protect what we generally think of as inventions. Now, as you're going to learn today, there's several different types of patents. There are utility patents, design patents, plant patents. Now, trademarks. I like to say that nearly every business, if not every business, has something protectable by a trademark. Trademarks are the identifier of the origin of the source of goods and services, incredibly valuable, and oftentimes for a company, the most valuable form of intellectual property. Copyrights protect the creative work of expression placed in a fixed intangible medium, and it covers a wide array of things. Similarly, trade secrets can protect a wide array of things if those things bring value to the business, commercial proprietary value to the business, and can be maintained as a secret. So we're going to do a little bit of a deeper dive on all of these here in just a moment. So here's a great example to get us started, because you may be thinking, oh, I don't know the first thing about intellectual property. Well, in all likelihood, you have certainly created intellectual property in doing many different things, but you most certainly have been a user of intellectual property. And that's, again, one reason why it's so important to understand and appreciate intellectual property, because not only are we creating it, but we are users of it, and we need to be respectful of the rights of others. So if we look at an Apple iPhone, which you may have on the desk there in front of you, or even in your hand right now, you can see that there are multiple forms of intellectual property inherent in an Apple iPhone. There are trademarks protecting the name and logo, the name of the phone. There are patents, numerous patents on the technologies located in that single device. Data processing methods, semiconductor circuits, chemical components, battery power control, antenna, glass display, to name only a few. Copyrights, of course, can protect the software code, the instruction manual, the ringtone. Trade secrets, now remember, it's inherent that we have to keep them secret for them to bring value. So if there are trade secrets covering some type of element of intellectual property in an Apple iPhone, we shouldn't know it and probably don't know it because it's been maintained as a secret. And then, of course, there are also designs which result in design patents that can protect the overall appearance of the phone, things such as the arrangement of camera lenses and the placements of buttons and switches. So this just brings it home for us that we are all experiencing and using intellectual property probably at nearly almost every moment of our day. So let's very quickly, before we jump into the 4 types of intellectual property, talk about why intellectual property is important for you as a business owner. So IP strategy is a business strategy and in fact should be part of your business strategy. And it should be part of your business strategy from the very beginning. I know all too often I talk to small businesses and they say, oh, Elizabeth, intellectual property is so complicated. I'm going to work on that when I have more time or more money or a better understanding and appreciation of what it is. I fully understand that. However, I can't condone that. I want to encourage you to think about intellectual property from the very inception of your idea, the very start of building a business. Because sometimes by precluding or by delaying in protecting your intellectual property, you in fact could be precluding yourself from protecting your intellectual property. So let's be cognizant of it from every step of the way, including from the very beginning. So for a business owner, your intellectual property portfolio, your IP, can be attractive to investors and buyers. Let's say you decide that you're done having that company, or maybe you want to transition on to the next one. If you have an IP portfolio, that is part of your bottom line that is going to be attractive to investors and buyers. Let's think of the simple example of the show Shark Tank. Invariably, the sharks will ask someone who comes before them, what type of intellectual property do you have? Have you patented that invention? Do you have a trademark? What's your brand? By having IP, you can deter infringement lawsuits by putting people on notice that this is your intellectual property and they have to come to you to obtain access to it, either through leasing it, buying it, or you're choosing to give it to them. It can increase your leveraging power as a business, and it is a property right. Going back to that conversation about real property versus intellectual property, just like real property, intellectual property is a property right and provides value. And of course, intellectual property is global. Now, with that, I want to caution, there is no worldwide patent. There is no worldwide trademark. Intellectual property is what we call territorial. It is protected within the country that issues you the right. So keep in mind, if you're going to be producing an invention, and you are here in the US, you're probably going to protect it with a US patent, but you're also anecdotally going to want to think about where your competitors are located, perhaps where you are going to sell, where you are going to manufacture, because certainly you could cover the globe in intellectual property, but that's a very expensive proposition. My apologies for that sideline noise there. Just a quick snapshot to show you how important intellectual property is to our economy and to the growth of our nation. You can see that intellectual property intensive industries create jobs which are higher paying. It contributes to the total gross domestic product of the nation and provides higher wages. So important to note that intellectual property, while it may feel like it's something under the surface, it continues to really enhance our economy, and it's very important to the growth of industry. So where do intellectual property rights come into play in a business? And I'm just going to click through this very quickly to let you know that they may come into play in a variety of different ways. Now, these each may be something that you are involved in or are considering being involved in your business or not. But these are just some of the ways in which intellectual property can come into play. Employee relationships, IP programs, business operations, government practice, mergers and acquisitions, software, and university tech transfer context. So just keep in mind that you should always have a vigilant eye out to where intellectual property rights may be coming into play in something you are doing. So what is the advantage to having a patent? Let's talk specifically about patents. As you can see from these statistics, they do help companies get a leg up. 5 years from having a first patent, there's a 36% employment increase, a 51% increase in sales growth. That's because a patent makes your company more attractive to others. That first patent grant can also increase the likelihood of additional patents as you create your portfolio and build upon it. It can increase the quality of patents as you become more familiar with the patent process and learn and grow and continue to file. It can facilitate access to capital, and it can reward your investors, those who have chosen to help support you financially in starting, building, and growing your business. It can also facilitate access to funding, as you can see. 53% increase in the probability of VC funding with a patent. And additionally, should that day come when you want to perhaps step away from that business, obviously your intellectual property portfolio can continue to provide value, particularly for someone who is looking to purchase your business. You are going to be provided with these slides, and I just want to draw your attention to this checklist that is going to be in the slides because I think it can be helpful to you as you move and progress throughout the growth of your business. This helps you to think of ways in which you might be engaging with intellectual property and where you might need to have that extra vigilant eye. So let's talk quickly about the U.S. Patent and Trademark Office. I don't know if any of you in Virginia have ever been to visit us in our Alexandria headquarters. That's what's featured here. But we are, as we like to call ourselves, America's innovation agency. We're also, for that matter, America's branding agency because we do patents and trademarks. Our work and the work that we've done since 1790 helps to foster innovation and economic growth. And we do so by creating a reliable, predictable, and high-quality intellectual property system. So what is the U.S. Patent and Trademark Office? We are a part of the Department of Commerce. We are an employee base of about 14,000 employees, the bulk of whom are our U.S. patent examiners who pick up patent applications for examination and to issue U.S. patents. We also have trademark examining attorneys who do that on the trademark side. As you can see, as I said, we are part of the U.S. Department of Commerce, and we are led by an Undersecretary for Intellectual Property and Director of the USPTO. That individual at this time is John A. Squires, a man who is well versed in intellectual property and leading us forward to great success. So let's do that deeper dive that I promised on the 4 different types of intellectual property. We are going to start with trade secrets. So let's jump right in. Here's 2 great examples of existing trade secrets. What is the recipe for KFC chicken? What makes it just so delicious? I don't know. Yum Foods has been able to keep that a secret for quite a long time. Now, do others make and sell fried chicken? Of course they do. Is it identical to Kentucky Fried Chicken? Probably not, because KFC has kept the recipe for their chicken as a secret. How about Google? How is it that when you put in a few keywords into a search bar, you end up with generally very useful results, depending? How does Google do that? Well, we don't know because Google has maintained their search algorithm as a trade secret. Now, again, what does that mean exactly? Well, trade secrets can be a wide array of things, but it has to be something that protects commercially valuable proprietary information. So, for example, a recipe, a formula, or business information could even be a customer list, something that gives that business a competitive advantage. Trade secrets are generally not known and must be subject to reasonable efforts to preserve confidentiality. And this is where, when I mentioned it briefly before, I said they're oftentimes protected by contract law. Oftentimes, you will have an agreement with your employees that they will not disclose the trade secrets of the business. Now, maintaining something as a secret can be done in a host of different ways, and I'll just give you a couple of examples. Perhaps if it's a recipe, perhaps not one employee has all of the ingredients to the recipe. Maybe each employee or a host of employees have several ingredients, but no one has or knows all of the ingredients. Perhaps the information is kept in a secure file drawer or on a secure storage medium that is encrypted. You have to take those reasonable efforts to preserve confidentiality. Now, can a trade secret be lost? Well, of course it can, either by nefarious ways or sometimes accidentally. Maybe the locked file drawer was left open. Maybe somebody ran out the door with that recipe or formula. So it is important that you take the adequate steps to prevent disclosure. Now, it can also happen by intentional or owner authorized disclosure, reverse engineering. And this is where one needs to think very carefully about what you choose to protect with a trade secret versus, for example, a patent. If your device, your invention is something which can be reversed engineered without little difficulty, you're going to want to think about protecting with a patent. Independent development. This happens all the time. Your idea is just so good, someone else has already thought of it, and it may have happened completely independently. So think twice about using a trade secret. Now, what is the value in a trade secret? I'll tell you one of the most important aspects of a trade secret, and that is the fact that it can last forever if it continues to provide valuable proprietary information to the business that is a competitive advantage, and it is maintained as a secret. As you'll see, patents and copyrights have a limited duration. Trademarks are somewhere kind of in between, and we'll talk about that in a moment. So let's talk about copyrights. As I said, copyrights are protected by the US Copyright Office, which is a part of the Library of Congress, but copyrights are the legal protection for the authors of original works of authorship. Now, just like trade secrets, copyrights protect a wide array of things such as literary, dramatic, musical, artistic, and certain other intellectual works. Interestingly, copyrights are what we call self-authenticating. By placing that original work of authorship in a fixed and tangible medium, you have a copyright. If you sat down and wrote a story this morning, and maybe you did that electronically, or maybe you did it on a pad of paper, if you recorded it on a fixed and tangible medium, a piece of paper, you have a copyright in that work. Now, what we were talking about and what we were encouraging is perhaps considering federally registering your copyrighted work. So what works are protected? As I said, that creative work of expression must be in a fixed and tangible form. The fixation need not be directly perceptible as long as it may be communicated with the aid of a machine or device. So think about a thumb drive. There's a tangible form of expression. So what works are protected? It must be an original work, meaning that the work was independently created. Now, what is the right level of originality? Well, it must have a modicum of creativity. Now, when people ask me about this, I'll give them the example. I wrote a grocery list this morning. I wrote it, I placed it on a piece of paper, so I have a fixed and tangible medium. But does that grocery list have the requisite modicum of creativity to constitute a copyrighted work? You know, it depends, but probably not. It's a mere list of shopping ingredients, so probably not. But now, what if I added a creative doodle to my grocery list? Is that a copyrightable work? Perhaps. So again, to touch on some of the many things protected by copyright: literary works, musical works, sound recordings, dramatic works, choreographic works, pictorial, graphic, and sculptural, motion pictures, architectural works. And this is just some of the things that are protected. So as I alluded to, Patents and trademarks have a limited duration. Copyrights have quite a lengthy duration, but it is a limited duration. Copyrights are good for the life of the author, whether that is a painter, a sculptor, an author, a filmmaker, life of the author plus 70 years. It lasts the full life of the author plus 70 years such that they can then assign it to their heirs. What are the exclusive rights that are enjoyed by the copyright owner, the individual who has created that creative work of expression placed in a fixed and tangible medium? Well, they have the exclusive right. And remember, that is the language of the Constitution itself, the exclusive right to reproduce the work, to prepare derivative works, to distribute copies, perform the work publicly, display the work publicly, or authorize others to do so. So now I have told you that copyrights are what we call self-authenticating. Why would you find it necessary or useful to actually register your copyrighted work with the US Copyright Office? Well, there's a lot of reasons, and I've got them right here for you. It puts others on notice of the copyright claim. You can use the Circle C. It is required to file suit in a federal court. Registration is a prima facie evidence of validity of the copyright. It may be recorded with U.S. Customs and Border Protection to help prevent the importation of pirated products. Very, very important. Statutory damages and attorney's fees may be claimed in courts, suits, provided registration is obtained within 3 months after publication. And it's certainly easier to license work, collect royalties, and enforce your rights outside of court. Registering your copyright is a relatively easy lift, and many do it without the assistance of an intellectual property attorney. It's most often done by individuals, and it is a pretty straightforward process. So I encourage you to visit the U.S. Copyright Office website. So let's talk about trademarks. Trademarks, one of my all-time favorites, and maybe that's because it's part of the US Patent and Trademark Office, but I also just think they're so exciting and, again, so valuable to a business. So what is a trademark? We generally think of a trademark as a brand. It is any word, name, symbol, or combination thereof used to identify and distinguish goods and services and indicate their source. Trademarks are good for trademark users and trademark purchasers. So let's say the consuming public, those who are producing the goods and those that are purchasing the goods both benefit from the use of trademarks. And here's several examples of well-known trademarks. I'm sure you've seen many, if not all of these. Now you'll see on this slide the TM, the SM, and the R with the circle. What's the difference? Well, trademarks, a little bit like copyrights, actually produce for you, that serve as a trademark by using a mark in commerce. Whether you register it with the US Patent and Trademark Office or not, if you use a mark, a word, name, symbol, or device or combination thereof to distinguish goods and services and indicate their source, you have a trademark if you are using it in commerce. And in that instance, you can use the TM. Now, just like a copyright, if you want to federally register your copyright and take advantage of additional protections, you will get to use the R with the circle. So here's some examples of types of marks: word marks, composite marks, special form marks, and design marks. These can all work together and in an intellectual property portfolio. As you can see, these are all examples of Coca-Cola. Coca-Cola has an enormous brand portfolio, an enormous wealth of trademarks that they use very wisely. So examples of trademarks, let's talk about a few more. Again, they can be words, slogans, symbols, designs, or combinations, but it can also be product packaging. Again, distinguishing the source of goods and services. Product design, trade dress. It can even be sound, color, or smell. And here's some great examples. The robin's egg blue of a Tiffany jewelry box, the shape of the Hershey Kiss, the color of Owings Corning fiberglass insulation. Another of my favorite is the United Parcel Service, UPS. What can brown do for you? That brown is their color. a scent trademark, and there's not too many of them. A personal favorite of mine is the scent of Play-Doh. So here's those examples of color trademarks. Again, the robin's egg blue of a Tiffany jewelry box, the brown of UPS, and the green of John Deere. Examples of trademark scents. Oh, the Gooby Grape Fuel fragrance. I'm not sure who's using that, but nevertheless, it exists. And of course, the scent of Play-Doh. Some sound trademarks. The NBC chimes and the sounds of Darth Vader, both the breathing as well as the sound of the lightsaber. You could hear those sounds with your eyes closed and know exactly the source of those goods or services. So as you begin to think about selecting a mark, selecting a trademark to serve as your indicator of the source of your goods or services, we want to empower and encourage you to develop something that will serve as a strong trademark, not a weak trademark. So we want to encourage you to select something that is fanciful or arbitrary. And I'll give you some examples here in just a second. Maybe even something that is suggestive. Where it gets problematic is if something is merely descriptive. And certainly if something is generic, it cannot serve as a federally registered trademark. So let's take a look at some examples. Oh, I'm so sorry those examples don't exist. But let's go back and I'll try and pull up a few from my memory banks. Fanciful or arbitrary, words that are created simply to serve as a trademark. Things like Exxon, things like Xerox. These words have no meaning outside of serving as a trademark. Suggestive. How about Coppertone? It suggests the result of using that product. Ever-ready batteries. It suggests that those batteries have such strength and quality that they will always be ready to provide you with power. Descriptive could be something such as something again that is describing the product or service in such a way, and again, keep in mind things that are generic, such as the word milk, cannot be used as a trademark. So the similar conversation as we had in copyrights, if trademarks are, in a sense, self-authenticating by using that mark in commerce, why register with the US Patent and Trademark Office? Well, by doing so, you expand the reach of your mark across the nation. You can now use that mark in nationwide commerce versus in the small or regional geographic area in which you have begun to use that mark. It provides a constructive notice of right to use. We will refuse later filed applications that are confusingly similar, because that's where our trademark examining attorneys do when determining whether or not to register a trademark. They are going to look to see if there is going to be confusion on the part of the buying public. They're going to look for the likelihood of confusion in these products. Is there a trademark which already exists for the same class of goods or services? If you register, you have the ability to use the R in the circle, the ability to prevent the importation of infringing goods. This again is through customs and border control. It can be used as the basis for obtaining registration in a foreign country, because remember, intellectual property rights are territorial. Statutory damages and attorney's fees are available in federal litigation relating to infringement. So let's talk patents. Let's get into the last of our 4 forms. So let's keep in mind, we've talked about trade secrets, which protect a wide array of things that provide commercial, proprietary, valuable information to a business if reasonable efforts are taken to keep them secret, and they can last forever. So remember, we first talked about trademarks. We then talked about copyrights, which are self-authenticating by placing that fixed, that creative work of expression in a fixed intangible medium. Copyrights are good for the life of the author plus 70 years and cover, again, like trade secrets, a wide array of things. We then talked about trademarks. You have a trademark by using a mark in commerce. to provide an identification of the source of goods and services, but we encourage you to register it with the U.S. Patent and Trademark Office to take greater advantage of that mark on a nationwide footprint. Now, keep in mind, one thing I failed to tell you is that trademarks are a little bit like trade secrets in that they can last forever if, and there's a couple of conditions here, if you continue to use the mark in commerce and you renew it on a 10-year basis with the U.S. Patent and Trademark Office. So renewal is necessary and use in commerce is necessary. For marks that are no longer in use, they become what we call deadwood on the register, and eventually they will be purged from the register, because we will ask you at certain points in time whether you are continuing to use that mark in commerce, and we may even ask for an example of its use just to make sure that you're using that mark. Because if you're not using that mark, we want to return it to the ability to be used by others. So we're going to bring it home now with patents. So what is a patent? Let's go back to the language of the Constitution. It is a right. It is a property right issued by the federal government, the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention without the owner's permission. Again, intellectual property brings so much value to the creative rights holder. It is for a limited period of time. Now, interestingly enough, this limited period of time has varied over time. Currently, for utility patents, it is good for 20 years. The protection is 20 years from the date of earliest filing. Design patents are good for 15 years from the date of issuance. And plant patents are like utility patents in that they are good for 20 years from the date of filing. Just like every form of intellectual property, patents are territorial, and a U.S. patent provides protection only in the United States. Currently, there are no worldwide patents. And I don't know what day we might get there. It'll be interesting to watch. So I've already alluded to this, but there are 3 types of patents: utility, design, and plant, that protect different things. Utility patents protect what we generally think of as inventions: a new toothbrush, a new cellular communication device, a new mousetrap. It protects how an invention works, functions, or is made, and it is 20 years from the earliest filing date. And it can protect a process, machine, article of manufacture, composition of matter. Now, design patents, incredibly valuable, often play hand in hand with a utility patent. Oftentimes in your IP portfolio, you may have both utility and design patents protecting the same article of manufacture. Design patents protect the way a product or article looks, basically the ornamental expression, and they are good for 15 years from the date of issue. Plant patents protect newly invented strains of asexually reproducing flowering plants, fruit trees, or hybrid plants, and are good for 20 years from the filing date. Think of rose bushes, fruit trees, poinsettias. So many beautiful things have been introduced into our world through plant patents. So for those of you who have never seen a U.S. patent, I encourage you to visit the USPTO.gov website and perhaps conduct a patent search. Or there's other means, such as Google Patents. But if you were to pull up a patent, it might look like this. Now, this is for something many of us recognize, a Keurig coffee machine. But its technical title, in looking at its patent, is apparatus with beverage cartridge holder having movable outlet. As you'll see, a U.S. patent has a very set form. And that can be one of the complications in applying for a patent. It is a process that is governed by U.S. laws and U.S. rules, and a lot of specificity. So for example, this apparatus with beverage cartridge holder having a movable outlet has a very technical title. You have to supply the applicant, the inventors. You can see from the face of this patent, you can see where the examiner conducted a prior art search in certain classes of inventions. You can see the references that were cited by the examiner, both US and foreign, because when a US patent examiner picks up your patent application for examination, they are going to search the world over for prior art, Prior art is just a term for anything that is published and publicly available and pertinent to the patentability of your invention. You can see from the cover of this patent, the examiner who examined it, the law firm which prosecuted it, and then also an abstract or a brief synopsis of what the invention is. You can also see the patent number and the date of the patent. Now keep in mind, as we've said, patents are good for 20 years from the date of earliest filing. Now this patent was filed on January 17th of 2014, but there's also a prior publication date. So we'd want to take a look at that to determine exactly when this patent expires. Now, as you think about perhaps filing a US patent application to receive a US patent, one of the first questions you need to determine is your idea eligible for patent protection? Because certain things are not. The patent laws of our country protect processes, machines, compositions of matter, manufacture, and improvements thereof. So what are some of the hurdles to patenting, and what can preclude you from receiving a US patent? And I say that because when you apply for a US patent, the US Patent and Trademark Office, not the rejection office, starts from the position that you are entitled to a patent unless. You're entitled to a patent unless we can determine that you are not. And why might we make that determination? Well, perhaps your invention is not novel. The laws require that your invention be novel, that your invention is new, not described in that prior art. Remember, prior art is anything that is published and publicly available, pertinent to the patentability of your invention. That might be US patents, that might be foreign patents, published patent applications, it might be websites or foreign trade publications. Is your invention non-obvious? Your invention must be non-obvious, and that the differences between your invention and the prior art would not have been obvious to someone in that field. Now that's a tough determination, both for you, the inventor, and for a patent examiner. I'll tell you that, having been a patent examiner, that can be a tough determination. And third, does your invention have utility? Does it function as intended? So what is not patentable? Remember, I said your invention, in order to receive a US patent, must be patent eligible. What is not patent eligible? You can't patent a mere idea. You must be able to describe your invention with such specificity that others can make and use your invention. Now, does that mean you have to have a working prototype? No, the answer is no. But you must be in such possession of your invention, again, that you can describe it with such specificity that others can make and use it. So I'll give you an example. I have a great idea. I want to create a time machine so I can go back in time and meet remarkable people like Abraham Lincoln. Do I have an idea, or do I have an invention? That's right, I have an idea, because I don't know the first thing about creating a time machine that could take me backward or forward in time. So I cannot patent my idea for a time machine. You also cannot patent natural phenomenon, and you cannot patent abstract ideas. So what is the path to a patent? How does this all happen? Well, it's a series of steps, and it may feel complicated, and this is where we encourage you to use the assistance of a patent attorney or a patent agent. Now, it's not required by law. You can go the road alone, but there is a bit of complexity in seeking a US patent. Now, it of course starts with a new idea, and that idea may be solving a problem in your life. It may be solving a problem in the life of your family, your community, or perhaps a larger problem faced by the world. But you have a new idea to solve something. Now, you may choose to file what's called a provisional patent application, but that's not required. We're going to talk about that in just a minute because it's a really useful tool. But ultimately, if you want a US patent, you need to file what we call a non-provisional patent application. That is what's picked up by a US patent examiner and can result in a US patent. So keep in mind, there is this tool called a provisional patent application. Juxtapose that against the non-provisional patent application. These are applications. There is no such thing as a provisional patent. I just want to use that word of caution because I hear it all the time. Oh, I have a provisional patent. The provisional patent is a remarkable tool, particularly for small business owners, someone who's just getting started with that kernel of an idea. It is something you can place on file with the office for a low cost of entry, a low bar of entry, and it is a 1-year placeholder. By filing that 1-year placeholder, it allows you to begin to use the term patent pending, and it allows you to begin to talk to others with the beginning of a sense of protection. Maybe you need to talk to people about funding your invention, or talk to people about commercializing your invention, or even just doing customer discovery. Try and have a provisional patent application in place before doing any of those things. Now, keep in mind, this 1-year placeholder is not examined or published. It has a 1-year time limit. It is only for utility patents. And again, it is a low-cost way to establish that early effective filing date. Now, it is the non-provisional patent application that is examined by one of our over 9,000 U.S. patent examiners. It is published at 18 months unless you request that it is not, and can become a U.S. patent. Now, keep in mind, we have issued over 12 million U.S. patents in our history and are rapidly approaching patent number 13. So what does the process look like? Well, I like to say that it is a process of communication and collaboration. It is a back and forth between you and the office. We don't want to be seen as a black box agency. We want to be seen as an agency of communication and collaboration as we work with you to hopefully arrive at a U.S. patent. You're going to file your application. It will be assigned to a patent examiner who has the expertise in your technology, whether that's chemical, electrical, mechanical, or business method. And they are going to pick it up, review its content, search the prior art, and determine if your invention is novel, non-obvious, and has utility, and then communicate their findings with you. This will begin the back and forth iterative process where you, or if you're using an attorney or agent, your attorney or agent engages with the examiner to hone and refine what may be patentable in your application. Assuming they find something that is patentable, it may go to issuance as a U.S. patent. So let's bring it home today before we talk quickly about some of the resources. Let's run through again, what have we learned today? We have learned that there are 4 basic types of intellectual property: patents, trademarks, copyrights, and trade secrets. We've learned that patents, trademarks, copyrights, and trade secrets protect 4 very different things, and they protect for very different durations. But not to fear, these may all be in your intellectual property portfolio as you begin to start and build and grow your business, depending upon what kind of an endeavor you're undertaking. Whether you've created a new dry cleaner or whether you've created the next hottest commercial product. Keep in mind, you want to be vigilant to whether you are creating something protectable by a patent, a copyright, a trade secret, or a trademark. And knowing the difference is incredibly helpful. So let's bring it home with some of the USPTO resources, one of which is our webpage, uspto.gov. I always encourage people to start here, to dip your toe in the world of intellectual property and get to know what you need to know. I always encourage people when looking at our homepage to start with the Learning and Resources pull-down tab that is available on that top horizontal toolbar. I also encourage people to go to the Find It Fast section and the public events. There's always a host of programs going on with the USPTO. Sometimes they're in person, sometimes they're virtual, sometimes they're hybrid. You can also see our initiatives, and this new to intellectual property is a great way to jump in and get your feet wet. So as we talk about the 4 basic types of intellectual property and knowing which one you are creating and how it should be protected, you may say, oh, Elizabeth, I've heard your presentation, I've got the slides, but I'm still confused. I want to encourage you to visit our website and to find our IP identifier tool. By using our IP identifier tool and answering 6 brief questions, you're going to get some feedback as to what type of intellectual property you may be creating and how it should be protected. If you go to that learning and resources pull down tab that I pointed out to you, you are going to find on that tab this inventor and entrepreneur resources page. I have to say, this is one of my favorite spots of the website. And it's just because the content that's laid out is laid out very digestible, and it's laid out in a chronological fashion. This is for inventors and entrepreneurs getting started before you apply for a patent or trademark, getting help to apply, applying for IP rights, and marching down that process after you apply, fixing an issue, entrepreneurial resources, and protecting yourself against scams, because there are scams out there. I've got to tell you, both in patents and trademarks, and I can speak to that as the U.S. Patent and Trademark Office, that there are scams afoot. People misrepresenting themselves as being the U.S. Patent and Trademark Office and trying to take your money. So please be cautious. We also have kind of adjacent to the inventor and entrepreneurs page is additional resources for startups. And these can include more information on protecting your IP rights, planning for success, finding funding, and engaging experts. And some of these experts are outside of the USPTO. You will find here, with respect to finding funding, some of our friends at the SBA. So we do work with our federal colleagues across the government to help provide resources to inventors, entrepreneurs, and startups. If you are considering filing a patent or trademark, or perhaps you already have filed an application, or perhaps you've even received your patent or trademark and you have questions about either one, patents or trademarks, we have two great resource centers. We have our Inventors Assistance Center and our Trademark Assistance Center that are staffed with remarkable people, many of whom have had 30, 40-year careers with the USPTO and are now giving back by answering your questions. These teams are available from 9 to 6 for our Inventor Assistance Center and 9 to 4 for our Trademark Assistance Center, and again, are there to help you no matter where you're at in the process. As I mentioned, on our homepage, you can find our USPTO events link, and there you will find a host of programs that you can tune in and learn, much like we're doing today. So I encourage you to come back and join any one of our classes. I do want to be sure and point out, for those of you who are considering filing a patent application, you oftentimes may hear what an expensive proposition it is. Now, I will say that the bulk of the expense is not in the fees that you pay to the U.S. Patent and Trademark Office, but rather into the legal assistance that you obtain to help you through that process. Now, with that said, I'm not throwing our legal community under the bus, because they serve a very vital role in helping you to navigate the intellectual property system. But just to point out to you, when filing in the area of patents, not in trademarks, but in patents, you have to identify what type of a filer you are. Are you a large entity? Are you a small entity or a micro entity? And as you can see here on this slide, if you qualify as a small entity or a micro entity, you get to pay the majority of your fees at a reduced rate. Our small entity filers must be an individual or small business, less than 500 employees, or a nonprofit organization, and you get to pay fees reduced by 60%. If you qualify as a microentity, meaning you meet the small entity requirements, you filed no more than 4 previous applications, provisional and patent applications don't count, you have an income not greater than 3 times the median income, and you have not assigned your rights to someone other than a microentity, you can pay patent fees reduced by 80%. What a dramatic reduction in costs. So as you begin to consider filing for a patent application, be sure to evaluate what type of a filer you are. Are you a large entity, small entity, or micro entity? Available to our stakeholders are something called Patent and Trademark Resource Centers, and they are located across the nation. As you can see, we have over 100 nationwide, and these are publicly available libraries most often at a college or university, where there is one or more trained librarian trained in helping individuals to set up a high quality patent or trademark search. They love to engage with the public. So if you are looking to conduct a search and are struggling as to how to put that together, consider consulting with the PTRC in your area. And you can find this map and links to all of our PTRCs on our webpage. Going back to the discussion of the cost of filing a patent application, we recognize that the cost can be prohibitive. So there are two programs, a law school clinic program and a patent pro bono program, that those who are of reduced financial means can take advantage of. If you find yourself in this situation, that you have limited financial means, that you are financially under-resourced, please investigate the USPTO Law School Clinic Certification Program or the Patent Pro Bono program located in your area. These have free legal services available to those who qualify, but you must qualify in order to take advantage of these programs. It requires that you have an income under a certain cap, that you have knowledge of what you're undertaking, and in fact, that you have an invention and not just a mere idea. So I will be leaving you with our contact information. Again, it's part of these slides, so you'll have it available if you have a question following today's conversation. With that, I want to encourage you to visit us not only here at the Alexandria, Virginia headquarters, but visit us on social media. You can find us there, and we've got a lot to talk about. So with that, I'm going to close out these slides. I'm going to leave you with the email address and phone number for my team and myself at the Southeast Regional Outreach Office. And thank you for your attention today. It was lovely being with you. I am going to stop sharing my screen and see if we have any questions today.
Thank you, Elizabeth. We have quite a few questions and we have 3 minutes.
All right, well, we'll do our best. I'll try and
do our best. And then I will ask you quickly, if the question doesn't get answered, should they email you or should they go to that list, depending on where they're located, and email from that contact list that you just shared?
Certainly, they're welcome to reach out to us at southeast@uspto.gov.
Okay.
And if they're located in another geography outside of the Southeast region, I am happy to forward them on to one of my colleagues.
That's perfect. Thank you. Okay, so first question was related to modicum of creativity and copyright. If I created an app using the grocery list I created, is it possible to protect the idea if other app developers create similar apps?
Well, so apps are a really interesting conversation. Apps, protected software, can be protected by one of two means. Software is protectable by copyrights, meaning the code itself, the code recorded in a fixed intangible medium, can be protected by a copyright. In certain instances, you may also be able to protect your app, your software, by a US patent. It is a complex area of patenting, and I'd want to encourage you to get the assistance of a patent attorney or patent agent who is well versed in that area.
For your Keurig example, was that one of design or utility patent?
That was a utility patent that I shared. However, Keurig may also have a design patent or multiple design patents, but the one that I shared with you today was a utility patent. And you know that by, if we were to go back, you could know that by the actual number of the patent. Where something is a design patent, the number of the patent will be preceded by the letter D.
Another question, do I need an attorney to file a trademark?
Great question. And there are remarkable trademark attorneys out there. So I would say it depends. A large percentage of our trademark filers do it independently, do it pro se without the assistance of an attorney. But the trademark bar of attorneys does exist. So, I can't give you legal advice, but maybe you try it on your own. And if you find it too complicated or need some assistance, then you go that route.
Let's see, another question. If I want to trademark both my company's name and its logo, would those be two separate trademark filings?
Possibly. It depends. It depends upon what your mark is. Is the name always going to be used with the logo? If so, that's a combination mark and it would be one mark. But if you anticipate using the name and the logo separately, then yes, those would be two separate marks. Now, you may in fact file three marks, one where it's a combination mark, one for just the name, and one for just the logo.
Thank you. Let's see. Can you share with us the practical resources to explore to register our PR, IP, TS, etc.? Not,
I'm not
yeah.
sure what
Joseph,
you
if you can elaborate or just reach out to Elizabeth, that would be great.
please.
Um, let's see. So we have so many. I'm trying to get through the ones that I think, okay, this is actually, I think, a good one. If you want to add a diacritical mark to your trademark, do you need to include the mark on your trademark application? And it further says these marks are used to help pronunciation. If your name is already approved without the pronunciation mark, can you still include it on the name in the future of the trademark?
Wow, that's a great question and a super deep dive. I'm going to direct that question to our Trademark Assistance Center.
Okay.
I would strongly encourage you to give them a yell and let them explain that to you.
Let's see. We're a little bit over, but Elizabeth, if you tell me when you need to stop, and if we need to stop, we can.
Sure. Why don't we take a couple more?
Okay. And then anyone who can stay on with us, that's great. So, for a joint product design and development effort between engineers and product managers, which key contributors should be included on the patent? Just the engineers, or should the product managers be included as well?
Wow, that's a great question. And my answer is it depends. To be included in the patent, an individual has to have contributed to the creative concept. Someone who merely stood on the sidelines and supervised or looked on, but did not offer a contribution to the creation of the invention, to the development of the invention, would not be appropriate to be listed as an inventor. So it is something that one must be very cognizant of, because sure, who wouldn't like to have their name on a US patent? But this isn't a place to reward someone for being in the room. They need to have contributed to the creation, contributed to the development of the invention itself.
Okay, so here's another question. If there are two patent request applications submitted at the same time of similar inventionary trajectory, how's the expert evaluating the application determine who is the rightful owner of such patent, trademarks, etc.?
Again, wow, what a savvy audience, Sheila.
Right?
Great question. So the U.S. Patent and Trademark Office has transitioned to be in greater harmony with the rest of the world. We have transitioned to a first inventor to file system. So in a sense, it is a race to the patent office. So the patent examiner picking up those applications is going to look to see which one was received first.
Good. Can you test a product idea with a prototype or mock-up with demos or online to get feedback while under a provisional and still apply for the non-provisional patent?
You can. During that year of your provisional patent application, that's a great time at which to investigate those things. Should I move forward? Is there a commercial market for it? Do I need to further refine my invention? Because by having filed that provisional patent application, you have something on file with the office that is forming the firm foundation of what, hopefully, if you move forward, will become the basis, the concrete of the foundation of that non-provisional patent application that you are going to then file and hopefully receive a US patent.
Let's see. We have an intro and a different outro statement in our vlog. Would this need to be something that is trademarked?
Oh, that's a question I have to admit I've never gotten before. Um, I think it's possible, but it could also fall underneath a copyright. I'd want to consult somebody about that.
Let's see. You want to take one more?
Sure, please.
Okay. Let's see. We have a lot of thank yous. Um, okay, here's one just as an idea because and it's probably something someone else is thinking about too. Is it possible to have a webinar specifically on IT intellectual property rights? Do you all do those?
So we have in times past done one on patenting software. We have had that conversation. It's not a class that we teach relatively regularly, but something that we might be able to investigate for the future.
Okay, great. Can you see the questions now? Did you want to take a look and see if there's anything you think we should share? If you don't see them, then I'll just ask anyone who didn't get their question answered to reach out to Elizabeth. So,
yeah, that would be great.
Okay, we'll do that. Do you have any last words of wisdom for us?
Well, I just want to leave everyone with the thought that, one, the U.S. Patent and Trademark Office is here to help you, whether through our Inventors Assistance Center, our Trademark Assistance Center, our Patent and Trademark Resource Centers, our regional offices, our Alexandria, Virginia headquarters. We are here to help you with the process. Again, don't think of us as a black box agency. We want to engage with you. But also, I want your takeaway to be, don't be afraid of intellectual property. We know you're creating it. We know you're using it. Remember, there's 4 basic types that protect 4 very different things, and I want you to use them to your success. Create that IP portfolio that's going to be part of the foundation of your business. Great being on with you. Always love coming out with the Virginia SBDC.
I agree. Elizabeth, thank you so much. So much good information. I want to thank everyone who joined us today and remind you, you are going to receive an email with a link to both this recording and to the slides. And you can choose your region to ask a question of, or pose your question directly to Elizabeth and she'll be happy to help. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiasbdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiasbdc.org or via our website. And we hope to see you all at our next sessions. Take care, everyone.
Thank you.